Yeah, a huge round of applause. So we wonderful, wonderful. We have coaches Vidya, Nidhi, Sharma, and more from the flute. We have Bhavesh, Shiv, Dipanshu, Nandu Prakash, and Yashraj, and vocalist. Accompanying them are teachers, Mr. Jaspal, Mr. Vaibhav Pant, and Mehrabali. The students have prepared this for weeks to come, so of course, very, very grateful for their experience. The moment is here. We'd like to formally felicitate our guests here. We have the dignitaries who are present amongst us. I request Justice Indu Malhotra to officially welcome all our guests for the evening today. May I please invite Malvika Kapla Kalra, Ananya Singh, Ashna Chawla, Chandray Vetka as they welcome our dignitaries. Can you give a huge round of applause? So let me briefly tell you about the evening today. And of course, we have a very, very learned audience and our panel speakers today, the Honorable Minister, the judges who are here with us today to tell you more about this. India is a bright spot in the entire world. With a fast growing economy and rapidly expanding trade and commerce, the need of the hour is to create ecosystems which are self reliant or Atmanirbhar. This course aims to train the policymakers and the lawyers of tomorrow to defend our national interests and ensure that India's commercial and investment related interests are that India leads the world in different arenas. This course is one such crucial step in building the right ecosystem, with adjoins from the world of law and politics supporting it. To hear more about this, let me take this opportunity to invite our first speaker. Let's begin today's evening as I invite the patron of this course, the one who sowed and nurtured the idea and ensured that it's
been an inspirational journey. She's the first woman appointed as the judge of the Supreme Court directly from the bar. She's an authority on arbitration, not just here in India, but her acumen recognized across the world. Presently, the member of court at the Permanent Court of Arbitration in The Hague. Please welcome the one and only Justice Indu Malhotra for the opening address.
The Honorable Union Minister of Finance and Corporate Affairs, Srimati Nirmala Sitharaman, Honorable Justice BV Nagarathna, Judge, Supreme Court of India and Visitor of NLU Delhi, Judges of the Supreme Court, present and past, Mr. R. Venkatramani, Attorney General for India, Justice D.K. Upadhyay, Chief Justice of the Delhi High Court and Chancellor NLU Delhi, Chief Justice of the Jammu and Kashmir High Court, Acting Chief Justice of the Orissa High Court, Judges from the Delhi High Court, Orissa High Court, Jammu and Kashmir, and Punjab and Haryana High Court. The Solicitor and Additional Solicitor Generals of India, Mr. V.K. Raja, President of the ICC International Court of Arbitration, who is a former judge of the Court of Appeal of the Supreme Court of Singapore and the chairman of this endowment. Mr. Toby Landau, King's Counsel, one of the world's leading arbitration practitioners. Mr. Damu Ravi, Secretary, Economic Relations, Ministry of External Affairs, officers from the Ministry of Law, External Affairs and Commerce Ministry, members of the legal fraternity, India and overseas, and my distinguished guests. A very warm welcome to all of you. It is my privilege to address you on the inaugural of the first postgraduate diploma certificate course in international commercial and investment treaty arbitration to be conducted by the National Law University of Delhi, which has been a beacon of legal education in India and has collaborated with the government in providing support in capacity building. This course has been conceptualized with the vision of training candidates from the legal profession, law officers from PSUs, state entities, and officers from various ministries, both in the center and the states, who deal with international commercial and investment treaty disputes with a view for domestic capacity building and reducing dependence on external counsel and ensuring consistency of representation on behalf of the Republic of India. India is increasingly becoming a significant player on the global investment stage. Such initiatives could facilitate the development of a cadre of legal professionals and arbitrators who are well versed in navigating through the complexities of international commercial arbitration and investment treaty disputes. India has been the third largest recipient of 1,008 Greenfield project announcements as per the World Investment Report of 2023. I will briefly mention the background in which this course has been conceptualized. Historically, India's journey started in 1994 when it signed its first bilateral investment treaty with the United Kingdom. Thereafter, India entered into treaties with 87 countries. India was then primarily a capital importing nation, which has now changed with its emerging status as a significant outbound investor. After the first adverse award was passed in 2011, in the white industries case, the government of India took a review of its bilateral investment program and introduced the 2016 model. In 2017, India terminated 64 of its old generation bilateral investment treaties, most of which were based on the Western model. Despite termination, foreign investors continue to initiate claims against the Republic of India under the sunset clauses, which have extended treaty protection for periods ranging from 10 to 15 years post-termination, which takes us to 2032. With India becoming the fastest growing economy in the world as per the IMF and its growing prominence on the global investment stage, this has necessitated a careful recalibration of India's investment treaty program. The existing investor-state dispute settlement mode is also undergoing a major transformation to balance the competing imperatives of investment protection on the one hand and sovereign regulatory space on the other. In many ways, the EU itself has been involved with this debate, and the intra-EU bilateral investment treaties is also reflective of this trend. I will now touch upon some of the challenges which are being currently faced by India and other developing countries. One is the filing of parallel or concurrent proceedings by foreign investors, both under the arbitration agreement in the contract and another under the concerned investment treaty. In some cases, there are vertical claims where shareholders at different levels of the same vertical corporate chain bring claims against the state based on the same cause of action. Another issue is the filing of claims by investors under different BITs on the same cause of action. A third issue, which I think is the most disturbing one, is the growing practice of trading awards in the secondary market to hedge resort to enforcement proceedings in different jurisdictions wherever India has assets. An example of this is the Devas case, where Jay Newman, the former head of the US hedge fund, Elliott Management, was engaged to enforce the award against India in different jurisdictions. The involvement of hedge funds has raised a serious concern when financial entities purchase arbitration awards through assignment agreements in the secondary market. They completely distort the balance between investor protection and state. This has resulted in an untenable situation where developing states face coordinated pressure tactics from entities whose sole interest is to maximize financial returns rather than maintain a productive long-term investment relationship. This has resulted in a huge drain and diversion of financial resources from the development of the country to defending itself in these proceedings. As India's infrastructure grows, the construction industry in India is it, which employs over 7 crore people in India. This has also led to a significant rise in construction arbitration, a tactic which is being resorted to by multinational construction companies is to treat each key milestone of the constructed cause of action with overlapping claims and grant of interest and costs at each stage of the proceedings. It is therefore necessary that the arbitration clause in construction contracts must be carefully framed to provide that the remedy of arbitration can be invoked only once, that is, at the conclusion of the works awarded or in the event of termination. These issues have created a serious legitimacy crisis and a worldwide reaction to dispute settlement. There is an urgent need for reforms both at the procedural and substantive level, particularly with respect to certain systemic issues which I'll just touch upon. One is a concern about lack of regional, ethnic, and gender diversity in the composition of arbitral tribunals which arbitrate upon such claims. Knowledge that the pool of arbitrators at present is largely divided as either pro-investor or pro-state. It is imperative to find balanced representation in arbitrage. The results of the award would be a foregone conclusion and not a fair adjudication. Another systemic issue is the inconsistent interpretation of identical or similar treaty provisions by different tribunals. A third is the mounting costs and prolonged duration of proceedings. A study was conducted by the Columbia University which reveals that the average amount expended in an investment treaty arbitration is in the vicinity of $13 million for the contesting parties, including the fees of the tribunal. Furthermore, another issue is that the absence of there's no appellate mechanism whatsoever, which makes it more problematic. I would advocate, speaking for myself, for complete transparency of proceedings in arbitrations which emanate out of treaty disputes, since they directly impact the taxpayer of the host state. The disenchantment and disillusionment with the contemporary framework is also evident from the withdrawal of numerous EU states from the Energy Charter Treaty, which is one of the most litigated investment instruments which contains ISDS provisions. In this background, I would like to make certain suggestions. First, The Government of India, while renegotiating its BITs, must take specific steps for terminating the sunset clause in the treaties which were terminated in 2017. This has been done by other states. By way of illustration, in May 2020, various EU member states entered into a treaty which provided for termination of about 130 intra-EU BITs together with the sunset clauses, expressly providing that the sunset clauses shall cease to have legal effect. In May 2021, the United Kingdom entered into an agreement with the Czech Republic whereby the BIT and the sunset clause contained therein was terminated. This is one issue which I think can be explored by the government. The second issue which I do want to touch upon, which pertains to judicial delays posing of corporate disputes. On this issue, I would like to first say that the ground of judicial delays can be a legitimate ground for maintaining a claim under an investment treaty. This issue has also to be viewed in the context that the Indian judiciary has probably the heaviest workload since it is catering to a population of over 1.4 billion. However, there has been a doubt amongst judges as to how can they be covered by investment treaties. And I do want to clarify this doubt as judicial process is considered to be a limb of state action, and it is the obligation of the state to provide effective means of asserting claims and enforcing rights of investors. Having said that, I believe we will have to take, the judiciary, my brother and sister judges, they will have to take steps to fast-track disposal of commercial disputes, particularly arising out of international contracts, pending in the High Courts and in the Supreme Court on a priority basis, since it has a significant impact on the economy of the nation. After the 2015 Amendment Act, which the definition of court was amended, and in cases of international commercial arbitrations, the jurisdiction stands vested in the High Courts. So I would request the judges of the High Courts to please fast-track it, have a special bench which is conversant with these areas of law on a priority basis, because it is a matter of national concern of our country, and therefore they have to be given priority. The way forward is only to designate one specialized bench in each of the High Courts and one in the Supreme Court to decide commercial disputes arising out of international commercial contracts and petitions for enforcement of awards arising out of treaties. Institutionally, the Supreme Court may also consider setting up a National Judicial College for promoting continuous education with respect to the fast evolving law governing international commercial and investment treaty arbitrations, as has been done in Singapore. These courses can be conducted by well-established arbitral institutions such as the PCA, which is the oldest arbitration institution in the world. In fact, in the 1980s, when I had joined the bar, I remember the Supreme Court would have these exchange programs which are called the Indu-UK exchange program. We had it with various jurisdictions, and I would urge the judges of Supreme Court to revive this practice because it's useful for exchange of ideas and it's a continuous learning process. The Honorable Finance Minister, in her recent budget speech, mentioned that India is revamping its model BIT to make it more investor-friendly in the spirit of first develop India. As India pursues its vision of being the fastest growing economy in the world as per IMF, it recognizes that foreign investment remains critical for its growth. It is necessary that the legitimate regulatory space of a sovereign state to take measures in public interest is balanced with the protections provided to foreign investors. This would help India in leading the narrative, in shaping arbitration practices in the global south, advocating
participation of women in judiciary is ensured when women occupy leadership roles. Her judgments have echoed the concerns of the marginalized, a judge who is robust in her judgments and compelling in her dissents. Ladies and gentlemen, please welcome Justice BV Nagarathna, the Judge of the Supreme Court of India, also a visitor at NLU.
Srimati Nirmala Sitharaman, Honorable Minister of Finance and Corporate Affairs, Government of India, Justice Indu Malhotra, former Judge, Supreme Court of India, and member of the Court, Permanent Court of Arbitration, The Hague, my distinguished colleagues of the Supreme Court, both sitting and retired, Chief Justices of the High Courts, Honorable Judges of the High Courts, distinguished guests and invitees, learned Attorney General, learned Solicitor General and Additional Solicitor General, Sri BV Nagarathna, Senior Counsel, former Judge of the Singapore Court of Appeals, and former Attorney General for Singapore and Chairperson of this course, Professor Dr. J.S. Bajpai, Vice Chancellor, National Law University, Delhi, Senior Advocates and Advocates, Practitioners in the field of arbitration, academics and researchers, faculty and students of NLU Delhi, members of the press, electronic and digital media, ladies and gentlemen. I deem it an honor to be invited to this inaugural program, the inauguration of the first postgraduate certificate diploma program of international investment in arbitration. The course is meticulously designed and is a brainchild of Justice Indu Malhotra's resolute commitment to developing India's arbitration landscape. In fact, it is her to deal with international, commercial and investment treaty disputes on behalf of the Republic of India, our country. The inauguration of this course by none other than the Honorable Finance Minister demonstrates her assiduous commitment to the development of India's stand and position in this branch of dispute resolution. The establishment of the chair on investment treaties and international commercial arbitration at NLU Delhi will have a transformative impact. This is not only for developing a cadre of qualified lawyers and trained public officers who would be well equipped to successfully defend the Republic of India in the cases filed by foreign investors and other actors, but also those who are interested in this area of scholarship. The chair instituted specifically for conducting this course under the leadership of Mr. BV Nagarathna, a well-known figure in international arbitration, will provide a platform for carrying out research of various models being followed by other jurisdictions and assist in the process of recalibrating India's treaty regime so as to ensure that a balance is struck between the right of a sovereign state to take policy action in public interest while also protecting investor rights. As India continues to grow as both a capital importing and capital exporting country, it is necessary that Indian investors receive similar and adequate substantive protection under the investment agreements entered into by India with other states. The globalized nature of commerce and the interdependence of economies has necessitated mechanisms which provide time-bound, impartial and effective resolution of disputes with certainty. Going back into history, I would say that September 14, 1992 deserves a place in India's economic history as a red letter day. On that day, the Government of India introduced new rules to allow foreign investment into the country. As a curious but natural consequence, the then Prime Minister Dr. Manmohan Singh, then Finance Minister
Dr. Manmohan Singh, later the Prime Minister, was confronted whilst in United Kingdom to answer what measures India would secure for the protection of foreign investment. His budget speech for the following year brought to national attention the criticality of bilateral investment treaties, BITs, in a globalized world. Soon enough, India developed a model BIT in the year 1993 and entered into its first bilateral investment treaty with the United Kingdom. That since then, India has signed BITs with 88 countries and has also entered into usually incorporating a dedicated chapter on investment, which are substantially similar to the standalone BITs. Historically meant to encourage and protect foreign investment by providing foreign investors certain protections, such as fair and equal treatment, protection from expropriation, and providing a neutral dispute resolution mechanism for resolution of their disputes. The investment is an exercise of constant innovation and reimagination. I am confident that the capacity building programs such as the postgraduate Diploma Course being inaugurated today will give an unprecedented impetus to Indian scholarship perspectives. Correctly called a watershed movement in India's BIT program, all stakeholders have found much to take from the first adverse award passed in the White Industries case against India in the year 2011. The tribunal of its India-Australia BIT on the sole ground of delay in disposal of cases in the Indian courts. With due respect, I find that the award reflects the lack of appreciation of the Indian judicial system, which caters to a vast population of over 1.4 billion people in accordance with the Indian law. Rule of law as the essence of justice is strictly followed by courts, Indian courts at all levels. Having said that, practitioners and future students of the field would be well advised to contextualize this instance as an indication of dynamism of law in the global world and the matter it demands. Following, I began working on a new model investment treaty. In December 2015, the government approved a revised text of the model BIT, which came to be referred as the 2016 model BIT. Now we are told that there's going to be another innovation on that. So therefore, the 2016 model BIT may have served as a template, but it cannot be the permanent framework. Therefore, the adoption of the 2016 model BIT, which was followed by significant steps that are contributing to reshaping of India's policy towards investor-state dispute settlement mechanisms, would be by further innovations. As already mentioned by Justice Indu Malhotra, there are 88 BITs that India has signed, 77 of the older generation. With the sunset clauses, there could be arbitration proceedings for a further period of 10 to 15 years. India has also significantly joined the joint interpretative statements with some countries like Bangladesh, Colombia and Mauritius to clarify the meaning of certain crucial provisions in the BIT. This is to limit the ability of the ISDS tribunals to interpret the treaties widely or to entrench upon the sovereign duty to frame regulations in public interest. I need not go into the decisions in this regard to this enlightened audience, except refer to CME Czech Republic BV versus Czech Republic, where the common interpretation was relied upon to clarify the applicability of principles of res judicata to the disputes arising from the underlying BIT. India is not the only country which is rethinking its BIT regime. The discussion is happening at a global level. These treaties are actually meant to encourage foreign investments by providing foreign investors certain assurances regarding treatment and protection of their investment by the host state, and also for providing for a neutral dispute settlement mechanism. The claims made by foreign investors have resulted in a review of Indian taxation laws, criminal laws, and judgments of our courts, which are regarded as an integral part of our state's sovereignty. There have also been cases where investors have questioned the state's right to make regulations in public interest. One of the widely discussed cases in this regard is the tobacco giant Philip Morris against Australia, where the investor claimed that the country's new packaging and labeling requirements for cigarettes violated the investment treaty provisions. Another one is the Vattenfall Swedish energy company case. Disputes brought by foreign investors challenging policy decisions of the government taken in public interest is a matter of serious concern. The courts are often faced with this dilemma. These disputes have raised serious doubts regarding the legitimacy of the process of dispute resolution itself. Addressing this legitimacy deficit is at the course of discussion on reforming the ISDS system. For there has to be a balance between the interest of the foreign investors on the one hand and the country's sovereign interest on the other in a most pragmatic manner. A large number of states, both developed and developing, have been taking a relook at their investment treaty regime and recalibrating the ISDS mechanisms. I am informed that globally, countries such as Australia, Germany, Indonesia, South Africa, European countries including Poland, Romania, and the Czech Republic, and countries in Latin America such as Peru, Bolivia, Ecuador, and Venezuela, and a host of African countries have endeavored in this exercise. India's past experience in commercial and investment arbitration has highlighted significant challenges which are faced by most developing countries and have brought to the fore the urgent need for capacity building to engage with complex investment treaty defense of the country. In my view, a comprehensive understanding of investment treaty arbitrations is indispensable, not only for protecting foreign investments in India, but also for creating a balanced and equitable investment regime which respects state sovereignty while fostering investor confidence. This intricate balancing requires the legal and academic communities to analyze and navigate the nuanced obligations and protections enshrined in BITs and international investment agreements. This course and several following its template can play a pivotal role in developing subject matter expertise to help the government deal with high-stake claims by engaging in consultation at an early stage rather than letting the matter grab. Question was whether we have a SOP to deal with these matters in India. My only suggestion is, since the Honorable Finance Minister is here, that there should be an inter-ministerial take it up as a joint venture, so to say, rather than each ministry looking at it independently. Therefore, a need to have a consensus built at the very initial stage so as to have the strategy developed in the initial stage is very critical and important. Historically, with respect to high-stake commercial and investment arbitration, India has engaged foreign law firms and depended on external expertise. There is no lack of legal talent in India. This dependency not only adds significant costs to the government, but ultimately is also a drain on the exchequer. Therefore, the need for such chairs and courses. By fostering a new generation of skilled and competent experts in the field of international arbitration, this course will empower Indian legal professionals to competently handle cross-border commercial disputes, reducing the dependence on external resources and talent, and to contribute to doctrinal development of unique perspectives that India can address as a leader of developing countries and on the cusp of entering the developed nation status. The systemic defects can be suitably addressed only if we carefully develop a theoretical framework with a pragmatic approach which balances investor protection and the developing to pursue policies in sovereign and. As I conclude, I have an article authored by Eric Gottwald in the American University International Law Review, which extols the stark disparities in legal resources and expertise between investors and in the context of ISDS arbitration proceedings in the case of CDC versus Republic of Seychelles. Seychelles is a country with only 80,000 population. How the problems that the Attorney General of Seychelles faced in defending this matter and ultimately resisting the costs, not only at the initial stage, but later on when Article 52(1) of Washington Convention was invoked for getting an award stating that it had no merit in its case, an additional cost is worth reading. For this reason, the institution of this course must stand as a significant milestone, not only for India, for the developing world, particularly in Southeast Asia and surrounding countries. It is a legal expertise cultured by this course will be employed not only in aid of India, but also other countries. This is to achieve a balance in investor protection on the one hand and sovereign interest of a country on the other. Let me once again congratulate NLU Delhi for taking the initiative of starting this certificate course with the participation of international and leading experts in the field. The participation of officers from the government, public sector agencies, lawyers and faculty members significance. This course is not merely an academic endeavor. It is a vision of Justice Indu Malhotra that seeks to shape the future of investment treaty arbitration and pivotal player on the global stage as an institutional powerhouse. I extend my hearty congratulations and felicitations to the organizers, faculty and participants, and I look forward to witnessing the transformative impact of this program in the years to come. I once again acknowledge Justice Malhotra's munificence for taking this important initiative. I am sure she will find time from her busy arbitration schedules to address the participants of this course, particularly in giving an overview of the significance of this branch of law. I believe that sharing of knowledge is the best form of generosity, for nobody loses anything but everybody gains. Capacity building initiatives such as this not only would build such confidence in the persons handling this branch of law, but also enable to strategize better in future dispute resolution processes and consequently protect and enhance India's financial interest. On this occasion, since I see Honorable Chief Justices from certain High Courts present here, I would recommend the Chief Justices of all the High Courts in India to depute their judges to avail the benefits of this course, which can be separately scheduled, possibly at the National Judicial Academy, so as to adjudicate more effectively the cases which arise in this branch of law in the High Courts. I wish the NLIU Delhi and all stakeholders of this program the very best in their endeavors. I am sure that they would devise the course module in a more suitable way to enable persons to handle such kind of disputes in whatever capacity they may do. Thank you. Thank you for your kind attention. Namaskar.
Thank you, Justice Nagarathna, for sharing your knowledge and for your generosity. Our next speaker requires no introduction. As the Union Minister of Finance and Corporate Affairs, she has effectively guided the Indian economy in the right direction. Whether it is upholding a strict fiscal discipline or carefully balancing the demand for direct benefit programs, her exceptional leadership has insulated the Indian economy from global shocks while maintaining steady growth. As India expands its presence in global trade, the government and judiciary emerge as vital partners in advancing countries' interests. The latest budget also announced measures to make bilateral investment treaties more attractive for foreign investors. Ladies and gentlemen, please join me in welcoming Srimati Nirmala Sitharaman, Union Minister of Finance and Corporate Affairs, for the inaugural class.
Justice Nagarathna, Justice dignitaries on the dais, judges from the Supreme Court, Chief Justice of High Courts, judges retired from the Supreme Court, retired from the High Court, legal luminaries, learned guests who have come over for this program, media. I'm extremely honored to be here on the invitation of Justice Malhotra, and I think it is a very interesting beginning, and I appreciate the efforts that Justice Malhotra has put in getting all this together. India definitely needs a very structured course to speak on how the developments in the arbitration world is going on. And both of them spoken in detail about the situation which is developing around the world, how India needs a framework, and how India desperately needs for all our young minds to at dealing with treaty-related arbitrations. Congratulate just an effort which is so required for India at this stage. I also think the National Law University in Delhi is the best suited place where she's chosen to install this and carry forward the work that she has planned. It's the second ranked or rated law school in India under the national NIRF rankings. So it is just the right place for a work of this nature to be located from. I also appreciate the involvement of Mr. V.K. Raja, who has served earlier in Singapore as a former judge of the Court of Appeal and High Court of Singapore, and also a former Attorney General of Singapore. These bright minds with a lot of exposure and experience are just going to make this very course very rich and much envied course for many others who don't seem to have the access immediately, but I'm sure in the medium and long term, most people can benefit out of a course of this nature. It is one thing for to have their courses periodically reviewed and add elements which are in the growing domain. But it is distinctly different for a judge who has seen it through her career and now who is still active in the arbitration domain to conceive of a course and to have it in such a way that it can be delivered with a time span of only 4 months, because when you're going to take this course practicing law and you're not going to have to do the same extent of time in acquiring this knowledge. And therefore, I appreciate the call that Justice Nagarathna has given to all her brother judges and sister judges to make sure that members of the judiciary can participate in this course and acquire the expertise from there. A lot has been said about the BIT, and in my short span in the finance ministry, I've had some experiences which in this context I'd like to share. And in my mind, those are the evolutionary consequences, evolutionary change which is happening in the BITs of the world all over. But because of that, being at one end of the BIT story, India has quite a few challenges to face. And those challenges are helping us shape as to how we can deal in the future with our BITs or with our arbitration. And in that, one of the very important elements is what Justice Nagarathna spoke about. I appreciate and I thank her for having that thought shared here. India's governance mechanism should have an SOP for handling at the earliest stage when arbitrations set or start rolling out. And in that, it is important to have very senior level bureaucrats from various concerned departments for which the arbitration will have something, or in that particular case will have a relevance, to be alerted and come in the form of a quick response team, the QRTs of the world, so that they understand the dimension, its implication, the collaterals which come out of it, and in stages start planning for a considered and well thought through response for such an action. We do not have an established institutional mechanism for it. Ma'am, you're right in pointing that out. We have been, as in groups, and I can say in my 5 years, I've had that instance more than a couple of times. Of course, the bureaucrats come together quickly and take up the matters, but even bureaucrats sometimes need those who are exposed to global arbitration environments, ecosystems, to advise and to take them forward. So one, to have standard operating procedure as to what happens when and who's got to respond and how, as a laid down institutional arrangement which should fall in place. There is a notice for an arbitration from somewhere. And also to have that level of external input and advisory coming in is equally important. So I take your advice, ma'am, and I'm sure we'll be able to work together with at least immediately the Finance Ministry, the Law Ministry, and the MEA. And I'm happy the Secretary East is here, and he's also taking care of the arbitration-related matters. So we should be able to come up with some kind of a setup. As was mentioned earlier, investment treaties have focused on the investor security protection, and also later, as we find, as in India's case, you have ranging from 1994, when the first bilateral investment treaty was signed with UK, 1996 when the code was also passed, and after that you have till 2016 that old BIT running currency. Yes, about more than 80 countries came in and we had signed agreements with them. But even as we were signing, the deficiencies which we were facing. And that necessitated a fairly impactful decision when we called off all the old treaties and said a new template is being brought in, and it is the new template which will run currency from then. And since after 2016, we've had a few countries coming in, but even 2016, I'm sort of moving fairly rapidly on the years, but even 2016 BIT template has been found inadequate to meet our requirements. As a result, in 2024, where we have signed two BITs, one with the UAE, and other thing, also as Justice Nagarathna rightly pointed out, as a part of the, you also had dealt with it when you were talking about the Australian experience. But we also see that even developed economies are now moving away from the old BIT, which looked at investor protection, but I believe inadvertently led to a situation where sovereign space was completely left open and loose. As a result, the BIT did not ensure that the sovereign domain is protected adequately, and I find, in my own limited experience, I'm sure if you study more of the developed economies and their sovereign space, you will have more information. But my limited exposure to the global south, countries who are developing, and some emerging markets, and India, have borne the brunt of our policy space being encroached. And as a result, you end up with a situation where you're trying to scramble the arguments to restore what is the right of the parliament, what is this right of the sovereign state, especially I take one example, but there are very many more, especially on matters of taxation. As a result, you end up going from one jurisdiction to fighting for your sovereign right. And that is where the BIT 2016 has been improved upon in bits and pieces when we are dealing with newer investment agreements which we are signing with other countries. And also a deliberate step which we may consider, we are moving a little forward on that, is along with an FTA to have a chapter of BIT, sometimes also makes the BIT become a negotiating card. Issues related to BIT are so unique to the sovereign that we think BIT should be negotiated as a standalone negotiation rather than make it as a part of a FTA agreement. However much good negotiators take this route forward, we still think BIT and its ramifications are so important for the sovereignty of the country. It is important for us to have a BIT standalone with specialists who deal with taxation laws and other policies which are very inherent to policy making, other elements of policy which are inherent to policy making, to be handled separately with due expertise. As per the UNCTAD, UN CTAD, Trade and Development Council, there have been 1,368 registered investment treaty cases. On an average, most of these cases, almost 70% of these cases, are pursued against developing nations based on the old generation treaties. And that is where, I'm sorry to make it a sweeping statement, but I'm sure you will indulge me. It may not be the case in every case, but that is the worrying element for developing countries. Based on the old generation treaties, when cases are filed against many developing countries, it allows the investors to maliciously seek unfair benefits from them. One can always argue, no, if there is a legal and merit in it, there's no wrong for the investors to go ahead asking for justice. But now, which Justice Malhotra referred, I think, in her speech, there are deep pockets, commercially interested deep pockets, who buy out one of the arbitration parties. And they can run this for long and long periods, which no sovereign state can afford fighting it out in so many jurisdictions at a time, and also for the longer duration it continues. And therefore, for just the desperation of not being able to do, you're fatigued out. End of the day, the case is won by the party who's got the deep pocket. I'm not saying this for all cases, but there are anecdotal examples from very many developing countries with whom we sit and talk during our bilateral meetings or when we attend the multilateral meetings. So developing countries in particular feel that their resource crunch and also their limited scope for people to fight this out in so many different jurisdictions at the same time just constrains them from seeking the right justice that they expect to get for their people. The average amount sought by investors in investor-state dispute settlements, the ISDS. So the ISDS cases is about 1.1 billion US dollars. This is an average number which has been narrated, which is considerable for the global south. So there's been little to no scope in the investment treaties for the nations to regulate in the light of public policy objectives. Powers of the nations which are much needed for the growth and evolution, which is the point I referred to, whether it's resource or the time, So the powers of the nation, which are much needed for growth and evolution, have been shunted away with the existing framework, especially when it curtails the power of the nations to make measures effectively align themselves with the growing needs. So, though the new generation treaties have started putting specific articles on the right to regulate, it remains to be seen whether these refinements will be interpreted in line with the treaty parties' intent by the arbitrators. So there's a big if even there, although you're bringing this element of right to regulate through specific articles which you're making as a part of the investment treaties. So corporations, as I said, have used this investor-state dispute settlement mechanism via investment treaties to challenge government policies. And now more of environment regulations and more of public interest laws. So you're further and further bringing calibration into the way in which a being interpreted. And as a result, your wherewithal to fight it will also have to, like in technology, you have to keep upgrading to meet up with the newer instruments or elements through which you're questioned about your intent. I come to a very important point which is very sacred for me, Arbitrators, and I would say often, arbitrators have ignored the judicial decisions of the host country. Things related to crimes like fraud and corruption, which have been established through the court of law in the host country, while arriving at an arbitration outcome, which puts the states in a conflicting position to accept the award. Now, when deep consideration is made, an investment treaty must not only provide better regulatory powers to the nations, but must also serve as guidance to international arbitrators to restore faith in arbitration. One element when you negotiate a BIT is also the time period for local remedies. We do underline the fact that before taking up an international arbitration, the two contesting parties should be given time to go through the available local remedies, because that's important for the host country. And it is repeatedly one thing on which questions are asked. I'm grateful that both judges, Justice Nagarathna and also Justice Indu Malhotra, have spoken about how the Indian legal system has to address the issue of 140 crore people. And therefore, to point that out, we keep arguing, but that is an issue on which BIT becomes contentious, where they wouldn't want to give us even more than 6 months, sometimes 1 year if they're kind, for local remedies. Within 1 year, for an Indian investor or for an Indian claimant to seek the court here within India and then say, all right, I've exhausted all the legal available options, well, I have to now go for international arbitration, is just next to impossible. And even this becomes an arguing, contesting, and negotiating point when you're sitting at the BIT table. I'm glad both of you addressed that, ma'am. So as I said, nations are becoming weary of international arbitrations. Many nations like Australia are moving away from the traditional arbitration model of investor-state dispute settlement. The recent practice of the Australia-UAE investment treaty is a good guiding example of this shift, wherein the dispute settlement mechanism is state-to-state dispute settlement. It is no longer the ISDS. They have arrived between themselves, UAE and Australia, that they will do a state-to-state. So I strongly believe, moving forward, the framework of investment, particularly the investment treaties, should capture national interest in relation to regulatory powers, strengthen guidance for arbitrators in resolving disputes, keeping in mind nations' interests and circumstances as well. So I think in that process, I am glad Justice referred to my budget mention about this topic. We have announced in the budget 2025 that India shall continue to keep its efforts to create an investor-friendly regime by revamping the model BIT of the 2016, keeping in mind the interests of our nation. So I quote from the budget speech that I delivered on 1st February this year: to encourage sustained foreign investment and in the spirit of first developed India, the current model BIT will be revamped and made more investor-friendly, unquote. So in a way, arbitration in some form has existed even in India, but I'm not going back to ancient periods. But what is important is international arbitration, supported by the New York Convention, ensures that the arbitral awards are enforceable in 160 countries. And if that is the extent to which arbitration has nicely spread, it should also look at the critical points at this stage where the world is facing multilateral challenges, not challenges of just trade, not challenges of institutions, global institutions getting weaker, but resolution for those fund flows which happen. Just as it was mentioned, India is an outbound investment destination. Indian money goes abroad for investments. They need protection as well, as much as the money which comes into our country. And therefore, the framework that we make for these investment-related matters will have to be robust. Commercial arbitration in India has seen a massive growth since its codification in '96. And this, therefore, will have to be something which will have to affect all of us. We need to look at competent people, professionals who can take up this matter, who will be on the top of things as the world is developing. And in that, I think, to give this kind of a support for commercial jurisprudence and knowledge and back it up with institutions and such credible, great panel of people who, with international experience, are going to help these students or practicing lawyers. That kind of an exposure is something which I greatly appreciate for the effort that you've taken. An International Arbitration Center, though I'm talking about the Indian experience, the steps that we've taken in the recent past, an International Arbitration Center will be set up in the city as per the announcement which we made in 22-23 budget for timely settlement of disputes under international jurisprudence. GIFT IFSC, the work is going on in drafting the rules for international arbitration. The report was submitted in July. We are actively considering it, and we should be moving forward on putting the rules forward on it. An arbitration bar of India was inaugurated in May 2024. My two colleagues, Jaishankar and Ashwini Vaishnav, had participated in it. This particular professional association will be helping in advancing alternative dispute resolution. The Permanent Court of Arbitration, PCA, is also setting up an office in Delhi, and the PCA's local presence will bring in greater potential, reduce the costs of arbitration. And in October 2024, the Minister of Justice has unveiled the Draft Arbitration and Conciliation Amendment Bill of 2025. Of course, this is going on. Several stages of amendments have happened, 1996 to 2015, 2019, and 2020. Now you have one more coming in 25. The New Delhi was created in 2019. That also shows our commitment towards strengthening the entire arbitration ecosystem. The center is also the India International Arbitration Center regulations of 2023. And under the Act, I think we continue to empanel reputed arbitrators, both for domestic and international arbitration, because a chamber of arbitration has been established. So, in conclusion, I would say this is a great attempt, brilliant step forward by Justice Indu Malhotra. I greatly appreciate her effort and her commitment to bring capacity in our manpower, in our specialists, in our professionals. I think we should greatly, all of us, support her. India needs to give that strength to our professionals, because that's only going to lead to greater India's own arbitration world, and above all, for the sovereign, it will be a great service towards bringing capacity in an increasingly complicated world. So thank you very much, Justice Malhotra, for your efforts, and thanks to all of you for giving me your patience here. Thank you.
Thank you, Honourable Minister, for that wonderful address, for highlighting concerns and what is the way and path forward. It's my great pleasure to introduce a distinguished leading voice in the realm of arbitration and international commercial treaties. Mr. Toby Landau is a well-recognized individual for his exceptional contributions to the field, serving as a pivotal figure in shaping best practices and advancing discourse around dispute resolution. He's one of the most sought-after lawyers in the international investment treaties, presently the King's Counsel and a go-to lawyer in the world of commercial arbitration. He's argued hundreds of major international commercial and investor-related arbitrations across the world. He was also the draftsman of the English Arbitration Act 1996. Ladies and gentlemen, please welcome Mr. Toby Landau.
Honourable Minister, Honourable Justices, distinguished guests, ladies and gentlemen, this is an inauguration of an extremely important, timely and welcome programme. It's important because India and Indian parties are now major players in both international commercial arbitration and in investor-state dispute settlement, both as claimants and as, of course, in ISDS respondents. It's timely because international commercial arbitration activity has markedly increased within India, because Indian parties are increasingly capital exporting and active outside of India, and because, as we've heard, India has faced and increasingly is facing ISDS claims with a huge potential exposure. That we build capacity, you build capacity within India. That means in terms of credible counsel and credible arbitrators. That you deepen the policy debate that is taking place within this country on both commercial arbitration and investor-state. And that collectively we prepare and best equip India to navigate and succeed in both prosecuting and defending these kinds of claims. My focus is on investor-state, and that has been the focus of all previous speakers. We've heard that in March 2023, the government of India terminated 68 of its BITs. But we've also heard of the sunset clause, which means that, like it or not, this country is stuck, for present purposes, with a lot of active treaties and therefore with an ongoing potential exposure. It's also fair to say that there is a bit of a turning point at the moment, or a crossroads, because in terminating those BITs, India also at the same time invited new treaty negotiations. And there are a large number of countries that are now increasingly pressing India for new treaties. It was reported indeed yesterday in the Indian press that Switzerland and Liechtenstein, Switzerland being the largest trading partner of India amongst EFTA countries, is now putting considerable pressure on India to negotiate and conclude a treaty. So it is now critically important that issues of policy in terms of future treaty portfolio are addressed, but also that given the sunset clauses, India tries to empower itself as best it can to deal with ongoing disputes. Now here, I switch to what I'm going to really, and that is the inside view. life at the coalface of fighting and deciding these cases. I've been an arbitrator myself in over 40 investor-state cases, appointed by probably around about 35 countries in all. I've been counsel in over 50 investor-state cases and a large number of India's investor-state cases, both for India in the white industries case, and I'm sorry to say, against India in a large number of cases. So large that I'm grateful to the government of India for granting me a visa. But that experience means that I feel I am equipped to tell you what it looks like in terms of deciding these cases, in terms of defending India, and I'm afraid in terms of acting against India. So here is your highly confidential inside look, not to be mentioned outside of this room. Firstly, let's recap on what you've heard already, which I'm going to distill in terms of the problems of investor-state arbitration as a mechanism. It didn't come out of the blue. It came to address a problem. And the problem is a long historical issue about how to protect foreign investors abroad. Without investor-state dispute settlement, there wasn't very much, actually. There was possible access to national courts of variable reliability. There was the system of diplomatic protection, and that, of course, used to turn up as gunboat diplomacy. Nothing like a blockade of a foreign port to focus the mind. And now, in the Trump era, we are in a world of tariffs and sanctions, increasingly. And so without a credible dispute resolution system, we may, I'm afraid, fall back on what are strong-arm tactics. They are politically complicated, they're often unavailable to investors, and they are highly unattractive. So that is, in a sense, why we've got this system before we simply abolish it. Abolishing, however, is not the only answer. There are alternatives. In the years since 1959, which was the first bilateral investment treaty between Germany and Pakistan, there has been an exponential growth in these treaties. The limit got up to around about 3,000 a few years ago before countries started to terminate, and that number started to come down. India, of course, started its portfolio in 1994, and as we've heard, by about 2015, it had signed 83 VITs. Even by then, 74 of them in force. Alongside the exponential growth in treaties, an exponential increase in claims. And what is very interesting here is how recent the field is from the point of view of international practitioners. Because whilst the first treaty was 1959, nobody noticed. These were Kodak moments, where a foreign delegation would be sent abroad with lots of business interests alongside and told, when you go there, you must agree something. There must be an occasion where people will take photographs with people shaking hands over a table with lots of flowers, and something is done. And bilateral investment treaties was often the candidate. It was signed, and then it was filed away, and nobody really focused on what it was doing. In the first claim against Pakistan, SGS against Pakistan, there was a wonderful moment, not well publicized, where Pakistan, having received notice of the claim, looked around and discovered it couldn't find a copy of the treaty. And the only option was through diplomatic channels to ask Switzerland, its counterparty, for a copy. That was how relevant the treaty was in those days to actual economic policy. That, of course, has changed as the generation of treaties have changed. But what's also changed is lawyers' awareness. And actually, I can think myself of a number of major claims that were fought before about the year 2000, which could have been treaty claims, but nobody realized that these treaties exist. Now we've woken up. And for India, that started actually quite early with the Dabol case. That was the first, Dabol and Bechtel was one of the first cases that actually people woke up to the opportunity of treaties. Now that opportunity has been seen, it has been truly embraced. And what that means is not only that numbers of claims are just going to increase, it also means that lawyers' ingenuity is applied to the terms of the treaties. And that means stretching concepts, such as what constitutes a qualifying investment, who is an investor, and what kinds of state conduct might lead to international responsibility. Because of that, the coverage has now exponentially increased. We are dealing with claims that were never contemplated when these treaties were first negotiated. this used to be a world of good old-fashioned expropriation of infrastructure projects. And now, it's about economic policy. It's about fiscal policy, taxation. It's about health policy, such as Philip Morris and plain packaging of cigarettes. It's about war policy. It's about states of emergency. It's about any element of sovereign discretion. And that means any clever lawyer can formulate a claim. And once that claim comes, what does it feel like for someone like me who has to decide it? And this is something you really need to focus on, because it's totally different to what it feels like in a commercial arbitration. The reason for that, well, there are a number of reasons for that, which I'm going to just identify. Firstly, your mandate as an investor states tribunal is to review any discretion. That means executive, legislative, and judicial. That means a grubby lawyer like me, private lawyer, is appointed to decide whether any act of the government in the exercise of its executive discretion was up to an international standard or can be impugned. Any act of your parliament, whether a law itself from a sovereign parliament is in line with international law and the guarantees in the treaty, and as I'm going to come back to in a moment in a bit more detail, any act of your judiciary, including the apex court. I, as a grubby individual private lawyer, can assess, review, and second-guess your Supreme Court in accordance with the standards in the treaty. It sounds bizarre, but it's completely standard, unsurprising as a matter of international law. The next point is, this is not like commercial arbitration, which might be thought of as a horizontal relationship between two contracting parties. These are parties who have agreed to come together into a process, whether it's a state or non-state and another party, and they will legislate for themselves in their contract. And the arbitrator comes along and decides the dispute. But this is a vertical relationship. This is like public law. This is an individual investor who is questioning state discretion vertically. That means asking a tribunal to assess the conduct. Example, I was appointed in the RWE case by the Netherlands, which was a claim by coal interests, arguing that the Netherlands' policy to ban fossil fuels in order to achieve the Paris Agreement goals was a breach of the BIT. So that means I have a mandate to decide whether the Netherlands can stop coal. That is an impact on everybody about climate change. And that's what was never contemplated when these treaties were initially drafted, as to actually what this mandate is and how it works. Now it gets worse. If you're not depressed yet, can you please prepare yourselves? I do this as an arbitrator, even though it's got a using a procedural model that was designed for commercial arbitration, not public law. That means I am only, as arbitrator, supposed to be interested in disputing parties, state, investor. The state may or may not be well represented, may or may not have resources, may or may not be handicapped by internal politics. If they are handicapped, if they're ill-resourced, I'm not going to hear all the stakeholders who the state should represent. I'll just hear whatever the state says. The investor will have its view. All the other stakeholders will not be heard, because they're not part of the process. The process is a contractual model. And the mindset of arbitrators is a contractual mindset, I'm afraid. I'm not naming names, though I'm tempted. As I always say, the day after I retire, I will be publishing all the names. There are people who come to this process refusing to see it as any different from any other arbitration. If I'm going to decide climate change in the Netherlands, shouldn't I be informed by all the stakeholders, be relevant for the policy of climate change? But unless they are brought to me, unless I have the nerve, the courage to go beyond the parties and ask for something else, I won't hear it. But it gets worse. Because when I'm deciding on whether or not this sovereign discretion complies with international law, I do so by reference to the standards set out in the treaty. The standards in treaties, especially old generation treaties, but also new generation treaties, are broad and unspecific. Why? Because when states negotiate wording in a treaty, they often can't agree. What they can agree is the lowest common denominator. That means broad language, That means they can then agree, they can shake hands over the table with all the flowers, and they can leave the room happy, each one of them with a different understanding of what the words mean. That's why, as often is said, the unofficial definition of a treaty is a disagreement set out in writing. And so, if I'm an arbitrator applying the standard, what have I got in terms of tools? It says fair and equitable treatment. It says don't expropriate, but it doesn't tell me anything much more, but it gets worse. We don't, in international law, have a doctrine of precedent. I can't say I'm bound by any other prior decision, even the ICJ. And so all I can say is, well, there are prevailing views this way and prevailing views that way. Now, as counsel, that is an utter nightmare. When I advise as counsel on investor-state cases, I have a standard paragraph at the beginning which says, I can advise you, but I can't tell you with any certainty because there's no precedent. And in the end, it actually depends on who you appoint as arbitrator. Right. But don't worry, because it gets worse. I have an authority to award damages for these breaches. There's no limit on what I can actually order. And damages have been ordered by many tribunals, increasingly so, with the help of experts which are brought to them by the parties. Independent experts, supposedly. These awards can be, in effect, massive allocations of a national budget without any accountability. These kinds of allocations normally would go through parliamentary scrutiny. As an arbitrator, in the UKOS Russia case, the award was $50 billion. In the famous CME Czech Republic case in 2001, there was an award against the Czech Republic of $353 million US. If we were to adjust that figure for gross national income and population size, that would be equivalent to an award against the United States of $131 billion. That was the entire healthcare budget for 1 year for the Czech Republic. In the more recent case of Tetian, Pakistan, an award against Pakistan for $11 billion US for a project that was never started. It was cancelled before anything was done on it. That 11 billion took up almost the entirety of one entire IMF loan that Pakistan had negotiated. It gets worse. There's no appeal. No appeal, no scrutiny, only limited procedural setting aside, setting it a limited annulment. That means, under the New York Convention principles, no relooking at the merits. But it does get worse, because there's also, of course, mandatory recognition and enforcement of the result. That is a recipe for potential disaster. And that's where the pressure is coming from. There in the actual application of this structure. So structurally, it's problematic. In its actual application, it's problematic. Because of expertise of arbitrators and because of costs and inefficiency in the process. And now we've got further developments which enhance all the other previous problems. And that is the advent of widespread availability of third-party funding, where that is allowed. And that, of course, is a question for India as to what it will do with third-party funding. Singapore has allowed it in limited circumstances. The old law of Shampati, as far as I know, still applies in India, but the pressure will be there to allow third-party funding. Third-party funding has its use as a form of kind of legal aid in international arbitration for entities that don't have access to resources, but it also has a financial, has in it the ability for parties to allocate their finances in a way that they want, and therefore feel more free about bringing claims. And lastly, as already mentioned by Justice Malhotra, the secondary market for awards. Vulture funds who are buying up awards and actually then seeking to enforce them. So with that happy context, let me just focus a little bit, one moment, just because I have the honor of senior judges. Just to focus a little bit on what the impact on the judiciary is. And I say this, of course, from my experience in having argued the White Industries case. I've said that the mandate of international arbitrators in investor-state cases extends to the judiciary. Now, that is explicable easily as a matter of international law, and that is the law of state responsibility, whereby India as a state, like any other state, comprises all of its integral components. And one component is the judiciary. So if a judge rules in a particular way, the state will be accountable for that as a matter of international law. That comes from a long law. It's now coded in the ILC articles on state responsibility, which date from 2001, and Article 4 spells this out. And bear in mind that Article 3 of those same articles emphasize the irrelevance of national law. It is no good going to an international tribunal and saying, but hang on, our Supreme Court is independent, you have no control over the Supreme Court, it's autonomous under the Constitution. And the answer is, so what? It doesn't make any difference as a matter of international law. As a matter of international law, that's your internal arrangement, but if judges rule in a particular way, the state has to pay the bill if there is found to be a breach of international law. It's worth then just focusing on what kind of breaches can happen. And there are two main causes of action that we now see in respect of judicial conduct. Now, I make it clear here, in order to safeguard my exit, that there's no suggestion whatsoever that any member of the judiciary here would ever be culpable of any of this. But let's think about other judges. The complaints are under two heads. Firstly, denial of justice. And secondly, an evolving concept we now have called judicial expropriation. Denial of justice is a subset of the standard of fair and equitable treatment. And that is a matter of customary international law. It has a long, rich jurisprudence. But what is now a little poisonous is the fact that fair and equitable treatment is expressed in bilateral investment treaties. So we look at the treaty rather than looking at customary international law. And in the jurisprudence on treaty language, there have now been a large number of instances where denial of justice has been deployed against acts or judgments, thank you very much, judgments of contracting states. Denial of justice can be procedural and it can be substantive. It's supposed to be a high threshold. I won't bore you with all the detail now. All I want to remind you is that there's no precedent. That judges, that international arbitrators have to take a view. And there are many instances where denial of justice has been found in circumstances where there's some surprise for people from the country in question who would have thought that this was the normal course of their court in accordance with their law to which they are all accustomed and not surprised. So denial of justice is one area. The second area is judicial expropriation. And that is without the major standard of denial of justice, which often has in it implicit standards of shock and horror or something which really is very, very perverse. Judicial expropriation is to take the rule about expropriation, which is you shouldn't take somebody's investment, and apply it to a judgment. By saying if a judgment has the effect of taking an investment, that can be tantamount to expropriation, and it's called judicial expropriation. Again, I'm not going to give you all the detail of that now, because I'll invite you to attend the course instead. But where this matters now is you get a crossover between commercial arbitration and investor-state. The crossover here is that if judges don't act in a certain way in relation to international commercial arbitration, the chances are they will face an investor-state claim. And that's actually where the bulk of this jurisprudence is now developing, even coming from white industries, which was this kind of case. And this is to be explained in the following way. An award, an arbitration award, is often analysed as an investment itself. It sounds odd. But what it often is the crystallization of a prior investment. You get an entity that will come to India and it will have a commercial arbitration agreement. It will invest. Something goes wrong with the investment, it loses money, it then brings a commercial arbitration and gets an award. Its investment is now reflected in that award. And that's where it takes the of an investment itself. And if that award is not treated properly in the courts, that's where you get an investor state. And what's calibrating this is really New York Convention legitimate expectations. The expectation that the courts will not unduly interfere. They won't unduly intervene. The expectation that you will get a result in a reasonable amount of time. The expectation that your award will be enforced. And there's a long line of cases now showing where courts have veered away from what's considered to be a legitimate expectation and find themselves then facing a claim in investor-state treaty case. So putting all of that together, where does that take us? And it takes us to a number of considerations, which I think this course, which Justice Malhotra has brilliantly convened, is a great forum to focus upon. So firstly, what are the points for India's future BIT portfolio? What should it be negotiating now? Should it be negotiating treaties at all? And if so, what shape and size? As I understand it, there are at least 37, if not more, ongoing negotiations at various stages at the moment between India and other countries. So this is a burning issue where policy input is absolutely critical. But beyond that, what is the practical reality now with the existing portfolio? So everything to do with new treaties is, in a sense, aspirational. It depends on negotiations, it depends on the future. But now is a critical moment, and it will be for the next 10 to 15 years because of sunset clauses. And what I can say is, from my experience at the coalface, there are concrete things that can be done to improve the position for states in India's position, to enhance its ability to defend itself, and to avoid claims even under the current treaty structure. Very tempted to stop there and say, if you want to hear about it, see my clerk. But I'm not going to say that. I'm going to actually tell you what some points are which can be developed in the course of this forum. So practical points, first of all, to navigate current claims. The experience now putting my hat on as counsel, and especially my hat as opposing counsel to India. The experience is that, as with most other countries, the first problem for a country such as India, in most of these cases, India, like other countries, will find itself obviously in a defensive position, but actually trying to catch up. The structure of this process, like any arbitration, is that the claimant has the luxury of time. The claimant can get together the entire case before commencing the process. Once the process is commenced, the state has then got to catch up. Hasn't had that time beforehand, that a claim is coming. Now, the point about investor-state cases is you actually have a cooling-off period in most of these treaties. You actually have 3 or 6 months available to you from the first notification of a dispute to when an arbitration will be commenced. That is a premium time period for the state to catch up and get ready. And as with most states, it's not used. Actually, for most states, it's a period of dislocation, a period where nothing very much concrete is happening until a notice of arbitration actually arrives on someone's desk. And so, as a structural matter, it would be to this country's huge advantage to have in place an institution that is triggered the moment that the process is triggered, that has in it access to information and assistance, and that actually means that by the time that the arbitration commences, the state has caught up. Second of that is to build institutional memory. Many government defending departments lack institutional memory. They'll build up memory on one case and it'll be lost on another case. And actually, as governments change, personnel change, information is lost, that is a huge problem for countries. And therefore, a structure to build a permanent institutional memory that can be accessed by whoever needs it is absolutely critical. Next, can I suggest one concrete thing? It astonishes me that a country such as India will instruct expensive international law firms to defend it in these cases and allow the international law firm to train its juniors on the case, but not have any junior Indian trained on that case. That's astonishing. Why doesn't India make it a condition of instructing an international law firm that the law firm use as part of its team junior Indian lawyers and train them up? You're paying a lot of money, and there's capacity building that they will be doing themselves, and that should be done for the benefit of the country. And next, and I'm going to finish very shortly, join up government in its defense. One of the biggest problems for states is actually joining different parts of the country that are responsible for one case. And not just India, it's many, many countries. There are worse examples. The classic example, actually, without naming any names, is Canada. Canada has, as many people say, it's got a huge amount of government, federal and then provincial and sub-provincial. And when they face claims, which they often do, they've got people all over the place who may be responsible. So actually tying people up into one unit makes a massive difference, and then producing protocols immediately as to how those entities are going to relate with each other, how information will be shared, documentation, possible witnesses, and assistance going all the way along. And lastly, the recommendation I have is for India not to shoot itself in the foot. And the easiest way to shoot yourself in the foot is in the run-up to a claim, and then in the course of the claim, have public officials comment on it. Or comment on India's BIT policy. Or comment on any aspect that actually might impact on the claim. So awareness is incredibly important, because otherwise you are creating evidence in real time. And there's nothing that investors enjoy more than introducing that in a claim against a state. Lastly, I finish with how do you avoid future claims? And avoiding future claims is problematic because a lot of promises which have been made in treaties, and this is one of their essential problems, the promises that have been made are unrealistic. The problems may not be actually attainable in the first place. But actually, apart from terminating sunset clauses, which Justice Malhotra has already mentioned, which is a possibility, although there are issues to be considered about vested rights, apart from having joint interpretive statements to interpret existing treaties, which is also possible, there is an increasing practice amongst some governments to try and identify potential claims ahead of time. And I give you one example. It's not a realistic example because there's no other country who can attain it. But that's Singapore. Singapore has a practice, but Singapore is not India. Singapore has a practice, which I have been involved in actively, where when a policy is about to be legislated upon or brought in by an executive act, they will first of all vet it for compliance with bilateral investment treaties. An active vetting exercise with the assistance of external counsel. And that is a process where the policy can be shaped and modeled to reduce the possibility of exposure to claims. Now, difficult in a country the size and complexity possible. It's not impossible to have a government unit that is designed, set up for it. And for that to be, for everybody who could be, to be made aware of it, to have the possibility for anybody to consult when there is a policy that could possibly excite claims. That makes perfect sense. And in fact, if that hasn't happened, you're almost always going to be sleepwalking into something that most people would never have heard of in the first place and therefore have contemplated. Ladies and gentlemen, there's much, much more to be said. And that's why this course is such a brilliant initiative, where these concrete issues should be debated to deal with the current position and where policy should be debated to deal with the future position. And for this, I will pay special tribute to the energy, the inspiration of Justice Indu Malhotra, and I wish all participants all the very best for this exciting course. Thank you very much.
different world, and it's a different India today that is living in this world. Let me start off first by showing you an illustration of where India is and what it has like. As they say, a picture tells you 1,000 words. It's just one illustration I'm going to show you. Now look at this. I picked up over the course of the last week, the 5 biggest economies in the world. China, Germany, Japan, India. Look at the number of cases that India has. After quite a few more were filed by 2015, and numerous others have been filed. So in terms of numbers, from what I know, India has got about 49 matters pending. 49 lost and won. So that's the total scorecard. Compared with all the other countries, Japan is in a unique space of its own. It's got something to do with culture as well. But look at the US. The US has never lost a single bid case. Look at China. Until 2 weeks ago, it had never lost a single bid case either. Germany had 2 cases, the Vattenfall cases, that it would likely have lost. But what did it do? It delayed it and settled it. So it's got a clean record as well. That was Japan. Now, India, depending on how you look at it, has lost 3 cases. There are 2 others, the taxation cases, the Kane case and the Vodafone case, where the awards were subsequently annulled. But that came after the legislation was reversed. So what has happened is this, as the speakers before me have intimated, once you lose a case, it's like sharks circling when they scent blood. Many more cases follow. If you're well advised, you don't lose a case. You will settle early. And that's another problem I'm told that India has. I'm going to be very candid with you, that sometimes decisions take a long time to be made, and sometimes there's a reluctance to settle for fear of being seen as being complicit with foreigners. So we need to look at also not just how we fight cases, but how you resolve cases that ought not to be fought. That's a really important point. For every case you've lost, and I agree, white in industries, there's a strong case to be made that was perverse in some ways. But leave that aside. India, now that it's operating in the wider world, cannot ask for 2 rules. Slower justice in India and more expeditious justice elsewhere. The truth of the matter, let me be very candid. If you make a treaty and you expect foreign investors to come and invest in India, you have to attend to those investments. As Toby has pointed out, the claims are investments in a timely manner. You cannot say that there should be 2 standards. An Indian standard for 20-year treatment of cases and a global standard where cases are heard in 5 years. Now, India, as the finance minister has rightly pointed out, has a dual interest today. There's an excellent book called Dealing in Virtue, written in 1996, and I don't think I would recommend it to all of you who are serious students of how the rules were conceived and what has transpired since 1996 to today, where Yves Zeller and Garth Bryant wrote a book about how effectively the rules of engagement for elite lawyers, rooms, and no guests, most of them, no guesses here, no prizes here, most of them were American, British, and French lawyers. The Global South were not at the table when these rules were devised. India and most of the Global South are not at the table today when these rules are being looked at. So one of the points I want to emphasize, and why I so enthusiastically agree with Justice Malhotra's idea, is India is lacking in thought leadership in this critical space. Where are your leading thinkers in the world of international arbitration? Where are your academics? Where are your writers? What are you contributing? You cannot, either you be at the table or you be lunch. Simple as all that. And this is an appeal I'm making to all the future leaders of India, some of whom are here and some of whom will join us as a course, that it is in your interest and the wider interest of the global south that India assumes thought leadership in arbitration, international arbitration, commercial arbitration, as well as investor-state dispute settlement. Make India a hub for thought leadership, even if it doesn't become a place for international arbitration or a seat for international arbitration. To go to the bench at bar, and Pallavi is here. And I said, it's a shame that Indian students today have to go to New York, to London, to Singapore for postgraduate instruction. You have got a real hunger, a real thirst for knowledge. And you can take inspiration for what has happened recently in the world of chess. And I'm not just talking about Gukesh, the world champion. To me, the most striking event was the fact that India won the chess Olympiad. And this has been a long journey. It's a 20-year journey because you have to look at how it started with Vishwanath Anand. He was world champion in 1998 and he was champion, but he inspired a whole generation. And today, this is to do. You have to light a fuse. So, as I see it, this course, this effort, this teamwork you've shown in putting together this course could be an inflection point. The challenge is continuity, innovation, and improvement. It can't stop here. It can't be a one-off. How do you then innovate and make this something unique, special? Let me give you some examples. Negotiating bids, negotiating treaties is a unique skill. Now, some of it you can go organically, but the best way of taking a quantum leap is by learning what others are doing and then improving and coming up with your own unique positions. You should be sending some of your brightest young people to work in some of the international law departments of friendly countries. Send them for 6 months, send them for a year. Build a nucleus. In a year or two, organize a course in India, maybe NIU or some other school, for drafting and make that a regular course where India also contributes to the global south and lifts its standard. Invite the best drafters in the world to come to India. They would love coming here to do and help build a culture of treaty negotiation. And in that process, you will have a say in how others draft treaties. You will influence others and not just let others set standards. You should be setting the standards. So that's one area. Second, lawyering. I completely agree, Toby. And Singapore is a bad example, but because it's small, it's easy to organize, and we had a head start in some of these areas. India has taken some time to come to the table and the realization that things can't go on as they have. You have to pull yourself together to work collectively. It can't be institutions and single ministries working in isolation. This has to be a whole of country effort. And I'm serious. It's the judges, it's the public servants, it's the academics, and every other stakeholder, those in the private sector, have to come together. You need to create unique, distinct Indian umbrella bodies to deal with these things. I commend, and I think it's a wonderful step, the initiative taken by the Attorney General and the Solicitor General to start the Commercial Bar Association for Arbitration. But that is just one small step. You need to create an ecosystem, a complete ecosystem And you can't leave it to chance. Leaving it to nature and nurture. And that's where I told the finance minister, the support today is the support of the government. She speaks for India. And her presence today tells all of us here today that India is committed to changing this culture of being second best. Is committed to this culture of letting others make the rules. India should not be a taker. It should be a maker. And I think that is where you have to really focus your efforts. And the future is in the younger people. I've met some astonishing lawyers in their late 30s, early 40s, some of whom have sat in arbitration and interacted in other different ways. So you have got an enormous pool of talent. The arbitration bar in India is attracting some of the best minds. Why? Because it offers mobility, offers good compensation, and most of all, the work is interesting. And we should create within India opportunities for those who may not have the income and the means to go abroad to actually get that knowledge organically. So I'm not going to go much further. I will be speaking more next week to the participants. But I want to say this, that it has taken a long time to come to where we are today, but I was also pleasantly surprised to learn there are two major events taking place in the arbitral world today. For this, we need to thank Justice Indu Malhotra, and I hope you'll join me in applauding her. I know from experience it's very easy to give advice. The hardest task is in execution. And she has been relentless and in terms of pursuing and inviting and approaching people to participate in this. And I'm sure the next edition will be even better. But I'm also pleased to have found out there's a separate event taking place in Hyderabad where another program is being launched. This program is invested in the present and the future, in policymakers and in lawyers based in Delhi who will shape policy for India. The NASLA in Hyderabad has set up a program for students, and that is an investment in the future. And I think India has a place for many such programs. I do really hope, as a friend and fan of India, because what you do is not just for yourself. There is a crying need in this area for thought leadership. And that is what something India can offer. If you look at how well you've done in so many other fields, it's because, to be very candid, the best minds have been inward looking. The best minds in the private sector in India, in law, have been so richly rewarded that many of them don't look outside for work. But it's different with the younger generation. And they must be given the opportunities, they must be given the platform to represent India on international platforms. Take for and the senior chair of the IBA, Chenpa, is here today. Indians are underrepresented, but worst of all, there's a quota. There's an Asian quota in the IBA for the number of Asian reps in different committees. There are quotas in many international organizations, which no longer make sense. You need to work with others to change. So I leave on this note. I see this course as just the beginning. It's going to be a journey full of twists and turns, but if we all work collectively together with the leadership that is being shown by those on the platform, I think if we were to come back in 20 years' time, this would be a very different discussion we're having. And last but not least, I wouldn't be too depressed about what Toby has said. Yeah, a lot of it doesn't make sense. And I can tell you why it doesn't make sense. Look at who made the rules. Some of you may be aware that in 2018, civil lawyers attempted to change some of the rules of arbitration by creating the Prague rules. But naturally, it got shot down by most of the lawyers in the large law firms and common law lawyers as making no sense. The Prague rules were meant to save costs, cut out discovery, and in my view, do many other sensible things. But there are too many people with vested interests who want to keep the system as it is. And this is where you can make a difference. Thank you very much.
Thank you, sir, for that address. Thank you, Mr. V.K. Raja, for that address. Ladies and gentlemen, we've been told that the Honorable Minister has work exigency, but she's already given us much of the promised time. Thank you so much, ma'am, for your time. Thank you so much for sharing your time with us. Ladies and gentlemen, can we please give a huge round of applause to the Honorable Minister for sparing a valuable time here. I request you all to please be seated while the Minister walks out. It's a security protocol, so I request you all to please be seated. I also thank Justice Nagarathna, who's been very, very kind to give us her time. Thank you, ma'am. Thank you so much for being a part of the event today. I now invite Professor G.S. Bajpai, who's the Vice Chancellor of the National Law University, Delhi, for a vote of thanks.
I'll be very brief and finish in next 5 minutes. So, respected chief guest now, Srimati Nirmala Sitharaman ji, who has graced this occasion for her gracious presence today. Honorable Justice BV Nagarathna and Honorable Justice Ms. Indu Malhotra ji. We have a galaxy of people sitting in the audience. Sitting and retired judges of Supreme Court and High Court, and in fact various High Courts of the country, learned Attorney General of India, and I must acknowledge the presence of Honorable Justice Devendra Kumar Upadhyay, who is the Chief Justice of Delhi High Court and also the Chancellor of National University Delhi. It is my honor and privilege to stand before you to offer the vote of thanks on this occasion. Before I say, I have just 2 things to mention. That the idea of setting up of a chair or number of rounds of discussion with us, and gradually this process fructified and we were able to visualize the conceptualization of this chair. And I must say that I have rarely seen NLU really has number of endowments, chair, foundations, centers, etc. But for the first time, it was our pleasant experience seeing a very senior judge investing personally in working out all minor details with respect to the organization of this chair. And as a result, she also discussed at length about this course. So the locating this course at National Law University under the edges of this chair is a great beginning. Many of you are aware that the National Law University Delhi is an ecosystem which is currently moving on 4 very important imperatives, because we are of the opinion that the legal education has to be very, very contemporary and must keep pace with the changes which we are witnessing in the field of legal profession and in the legal education. And I am personally, aware that this is very important for us to transform the way we impart legal education in our country. So therefore, as I have said, we are working 4 very important and very strong imperatives. They are research, innovation, entrepreneurship, and technology. We are factoring these 4 imperatives in all walks of our work, in all our courses, pedagogies, and all kinds of activities. Because we are of the view that so profoundly and so impactfully in terms of AI and other things, that we need to reimagine the manner in which we are conceiving the legal education as well as the legal profession. And we are also at the moment exploring the possibility of nurturing entrepreneurship in the campus of National Law University Delhi, for which we have set up a Section 8 company in NLUD Foundation, through which we are incubating a number of legal startups. And already we have accommodated two very interesting startups. They are customized legal tech startup which would be catering to the important solutions to the legal profession education. So this process is going on, and we would be soon incubating more than 30 startups at the National Law University, especially in the field of legal tech. As I have said, so we are working on the imperative. And this course become a very contemporary addition to the ecosystem of National Law University Delhi against this philosophy. And therefore, for which I am extremely grateful today to your kind presence. And to begin with, let me extend my deepest gratitude to our esteemed chief guest, the Honorable Minister, whose presence here today reinforces the critical role of arbitration in ensuring a seamless and efficient dispute resolution process in an increasingly interconnected world. We are truly honored for her gracious presence today. I am extremely sincere, I sincerely express my gratitude to Honorable Justice BV Nagarathna, who is the visitor of the National Law University. And I must say that it was simply not today she is present here and she spoke. She took a lot of interest in finalizing this program along with Honorable Justice Indu Malhotra in terms of working out all details. So, and she has demonstrated huge interest. Her unwavering commitment to the judicial reform and legal education inspires us, all of us. Her presence affirmed the judiciary's pivotal role in advancing the cause of justice through arbitration and alternative dispute resolution. To say the minister has just left. At NLU Delhi, we are thinking we have very ambitious plan. And some time ago, I have mooted this idea that there is a very remarkable experiment that the union government has done in the recent past in terms of converting now as many as 12 campuses across the country. This is the time to convert at least one national law university into a central national law university. That role National Law University Delhi can have a very path-breaking beginning in terms of its expansion, because we are feeling very constrained that we can provide leadership in different aspects of law by creating some world-class centers for which not only we need a space, we also need a very big canvas. And I think the union government must think in terms of at least having one central national law university devoted solely to the promotion of legal profession and legal education in India. But that task may take some time to fructify. Let me come to express my gratitude to Honorable Justice Indu Malhotra, whose dedication and vision have played a very instrumental role in making this course a reality. Justice Malhotra, your unparalleled contribution to the arbitration law in India and your relentless effort to foster expertise in this domain have left an indelible mark. The establishment of this chair stand as a testament meant to your dedication and will serve as a beacon of excellence for generations to come. I wish to express my heartfelt thanks to Honorable Justice D.K. Upadhyay, Chief Justice of Delhi High Court and Chancellor of NLU Delhi for his gracious presence and continuous support. So your leadership has strengthened legal education and nurtured academic excellence. I extend my profound appreciation to Mr. V.K. Raja, a distinguished international arbitrator whose expertise and contributions have profoundly shaped global dispute resolution frameworks. Sir, your willingness to lead this chair professorship is a testament to your commitment to excellence in arbitration, and we are privileged to benefit from your guidance and vision. And I am looking forward his presence on the campus on this 17th for the interaction with our student at the National Law University Delhi. I'm equally thankful to Mr. Tovey for a really wonderful exposition today. Your contribution to the development of arbitration law worldwide have been truly transformative. My special appreciation to Dr. Neeraj Kumar, who is the chair's faculty coordinator, and he has been working all through this event. Thank you for your contribution as well. Our esteemed faculty members, industry experts, advocates, senior advocates, mentors, your tireless dedication to educating and guiding our participants is deeply valued. Let me also acknowledge the presence of some pioneering cohort of the candidates enrolled in this program. Let me tell you that as many as 200 plus applications we have received for this course, which is fairly encouraging, and we are hoping to shortlist soon the requisite number of candidates for this course. And I'm equally thankful to the various government departments, and we have received the nominations from the industry corporate also for this course. And your decision to engage with complex legal frameworks and master the nuances of arbitration law signals a bright future for India's legal landscape. As we conclude this inaugural event, let us recognize that today marks more than an academic milestone. It represents a collective commitment to excellence, a pledge to build capacity and vision for India's more resilient and sophisticated arbitration framework. Through education, research, and collaboration, we are taking definitive strides towards ensuring India remains at the forefront of global arbitration and dispute resolution. I would like to take this opportunity to extend my gratitude to the organizing committee, staff, and every individual who has worked diligently behind the scene to make this event a grand success. Your meticulous planning, dedication, and relentless efforts have made this evening seamless and impactful. Without your contribution, none of this would have been possible. As we conclude, let us draw inspiration from the wisdom of our esteemed leaders, faculty members, industry experts. Let this moment mark the beginning of a new era, one that cultivates skilled arbitrators, fortifies India's dispute resolution mechanisms, and cements our nation's standing as a global hub for arbitration. On behalf of the National Law University Delhi, I extend my sincerest gratitude to each one of you for being part of this historic occasion. I wish you continued success, professional growth, and meaningful contribution to the international arbitration. Thank you, and I wish you all a pleasant evening and safe travels. Thank you.